Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now, it's my pleasure today to review a book which I think is one of the leading textbooks around at the moment. It's extremely well written. It's well known as an established work for people like myself at the construction bar. It's Keating on Construction Contracts, now in a 10th edition. It's been written this time by Stephen Furst, Queen's Counsel, and Sir Vivian Ramsey, and it's from Sweet Maxwell and THOMSON REUTERS. Is this book here, now with a sort of mauvey purple cover. This is a first-class book. We'll have a look at it in a second. The reason I say that is because at the construction bar we do have quite a specific jurisdiction to deal with, and there are quite a large number of texts available, but I think this is the best of all of them. Let's have a look at the book itself. It's a heavy book. It's a hardback. There's the front, there's the side, and then there's the back. Now, the book itself runs to quite a large number of pages, 1,200 odd pages. You can see from the index at the back that we are looking at paragraph numbering if you want to find anything, so it's quite important to know your way around. It's a very substantial index as well, and there's a little note about it right at the beginning talking about it's being prepared using the Sweet Maxwell legal taxonomy. And so it's quite important to remember we are moving at the moment into new areas with publishing very quickly with digitisation. So it's important to know how they actually create quite a lot of this. Now you can see the number of people involved. This is the front page. I've only mentioned Furst and Ramsey, but there are a lot of people who've been involved in this, and it's specific to areas within the book itself. And again, it depends very much on the problem you will have as counsel concerned with a construction matter, and of course solicitors will be involved too. This is the list of contributors, a large number of them, and important to know who has been actually involved in the production of this book. Then there's a publisher's acknowledgement thanking people because they've been able to quote quite a lot of things such as the JCT Standard Form of Building Contract 2011 and so on. This is the preface, 5 years since the last edition. And it's setting out, it says here, this is 5 years since the 9th edition, the way in which construction disputes are resolved has continued to develop. Now, I point that out just as a very simple statement, but I would say that it's continuing at the moment, and things are going to change again quite quickly, I think, with the way we're doing things. The two authors have set out their views there. Do read the preface because it's very important. Table of contents, quite detailed, so you should be able to find things pretty quickly. Nature of construction contract, formation of the contract running all the way through, quite a large number of, most of the issues that you'll be looking at are covered. And then towards the end you've got the standard form contracts, and then you've got some appendices which you can see at the back there. And then after that, the usual table of cases, all the suspects are there. Then you've got after the table of cases, very substantial number of cases. You've then got, of course, right at the end of that, you've got an additional table of European cases, not very many of those, maybe fewer of those in future because of Brexit, I don't know, but certainly not as many. Table of statutes, of course, again very important. Then you've got the SIs after that, and then we're getting into almost into the book. You've got, of course, table of European legislation. Again, I don't know how long that will be there. Certainly it's going to be an interface with that. And then there are references to the building contracts JCT, and then there are references to the infrastructure conditions of a contract, which are also covered at the back of the work. Then after that we get on page 1, which is there. You see how much of the book we've already gone through. This is chapter 1, page 1, which is the nature of a construction contract, which is an issue in its own right sometimes. Now you've got here an index to each of the chapters, which I think is very helpful because you should find things quickly. You've got the paragraph numbering down the sides, obviously a page number at the bottom, and you've got a lot of footnoting and subheads and so forth. There's a quote which I will use right at the beginning from Lord Diplock. A building contract is an entire contract for the sale of goods and work and labour for a lump sum price payable by instalments as the goods are delivered and the work is done. Well, that's the beginning of it, and then we know all sorts of problems that will arise as and when we're going through the timescale of the contract. But that's the starting point. You then go into the huge amount of detail that is here. This is by far and away the most authoritative work, and you should, within your own practice, be able to find what you're looking for in there without too much difficulty. So what do Elizabeth and I think of this? Well, she wrote the review and I've helped her with it, and obviously I'm doing the presentation. What we've said in our review is we've said construction contracts examined with thoroughness and clarity. The new 10th edition of Keating is out now, which is this one here. I'm recording this in the autumn of 2016 and it's been on the market for a little while. But what do we say about the book? Well, we say it's a long established and authoritative work of reference from Sweet and Maxwell, which deals with the resolution of construction disputes. It's never an easy task, as practitioners at the construction bar can attest to, because obviously we do have what are really very complex sets of fact management papers and everything else. In other words, there's a huge amount of paperwork and lots of attention to detail is an absolute prerequisite. So if you're one such practitioner who's faced with the complexities inherent in such disputes, not to mention the often enormous amounts of money at stake, that's true, the book should help you cope with whatever challenges ensue. And that, in fact, is the brilliance of Keating, and I think it's a first-class statement of where we are. It was first published in 1955 and updated at regular intervals thereafter, and of course Keating on construction contracts has become a definitive work from Sweet and Maxwell in this area of law, and it now emerges as authoritative as ever in a new 10th edition. I've said it before and I'll say it again for this review. We can't do our jobs without having works like this. That's either practitioners at the bar, solicitors, or the judiciary. These books are absolutely fundamental. They are part of the common law, and I'd like to thank everybody right at the beginning for the work they put in, because it does make our lives easier. Says a thank you right at the start. Now, the 10th edition contains much new material since the 9th edition, which was 5 years ago. And it incorporates the most recent developments by which construction disputes are resolved, including the increasing use of and dependence upon mediation and arbitration, especially in matters relating to international contracts. And I'll add another point to that, and that is in 2016, that's the way it is, quite quickly I think we're going to be moving to online systems, and that's going to make a big change probably in the 2020s. I know it's a few years away yet, but I think before you blink we're going to be there, and it could well be that we're going to have to reassess how we actually look at the way we're doing our business. Obviously the book today includes, for example, sections on mediation and dispute boards from contributors Rosemary Jackson and Robert Gateskill. Now I think that's important to bear in mind again, because mediation and arbitration is one very useful way. Bearing in mind the sums of money that can be involved here, it's one way of getting out of some of the difficulties. Now, in the words of the two editors, Stephen Furst and Sir Vivian Ramsey, the Technology and Construction Court, the TCC in London, and its regional centres continues to take the lead in providing efficient and cost-effective resolution for domestic disputes and functions as the chosen forum in international contracts. That was the case prior to June 2016, and then the disastrous decision to leave the EU as I see it. However, I'm not a remoaner, as they call us now. I've accepted the reality, but the fact is that I still think that we will remain the international chosen forum, and I hope that that does stay. International arbitration, especially in London, they add, continues to flourish, and that is the case, and I hope it remains that way. The TCC is a particularly interesting court to be in. I appear in it from time to time, and I do find it of most interesting, and these cases of course are also very stimulating intellectually, because they're interesting apart from anything else. Let me continue. There is therefore much commentary in the book also on significant construction cases that have been decided in the appellate courts. There is, for example, an updated chapter on the SCL delay and disruption protocol, which again, very useful to have that additional information upon. Each case and or regulation is explained, and in a lucid, plain English style, which we feel is typical and throughout the book, which makes it actually a lot easier to read. It's not a difficult book to read. You've got to have some understanding of the systems, but it's not that difficult. And I thank the authors for that clarity. It's fair to say that every practitioner at the construction bar, from novices to experts, will find that this book offers welcome assistance in helping them find their way around and through the complexities of what's a formidable regulatory environment. And to take an example, Clause 61, and this is only one example, which over 6 pages is examined and explained in some detail. And again, that sort of information is extremely helpful, I think, for practitioners and anybody involved in this area. Now, as the editors point out, the law of construction contracts is a part of the general law of contract. That's where its roots are, never to be forgotten. Remember the quote from Diplock that I gave you at the beginning. It's not to be governed by any general codifying statutes, therefore, because, as I'm sure you're aware, the law of contract is basically one of the main cornerstones of the common law. Now, they confirm, however, that's the editors, that where the general principles of the law of contract applied to problems of common occurrence in construction contracts, they've been dealt with in detail in this book, because what in fact the authors are doing, and the contributors, is to try to give you as much information in a one-stop shop book, if you like, so that you shouldn't need to do too much cross-referencing. You should be able to find what you're looking for. So let me conclude by saying that although over 1,200 pages in length, the book's been carefully organised for ease of use, with numbered paragraphs throughout, a detailed table of contents, the individual lists of contents at the beginning of each chapter, which again I think is great because it speeds up what you're looking for, and then the 48-page index. It's also worth noting that more than 190 pages are devoted to tables of cases, statutes, SIs and much more, plus the standard forms of key contracts and the 2 appendices at the back. Now, it features the expertise and insight of 28 expert contributors, so the new 10th edition of Keating belongs in every construction practitioner's professional library. Obviously, do make sure you've got the new edition because it's up to date, but it's got to be there if this is the area you practice in. Now, the editors have aimed to state the law as at the 1st of January 2016, and they've also sought to incorporate significant changes at proof stage where possible. And I'd like to thank them again very much for the work done. Let's have a quick look at it again. Keating on construction contracts, there we are. Side, nothing on the back. Just opening it up, and it's a heavy book, opening it up in the middle. Here we go, the right to insist on arbitration. Right, nice structure here. You've got the paragraph numbering at the sides, you've got some subheads, a lot of footnoting, and you should be able to find things pretty quickly. The index, which I mentioned at the back, that's the appendices at the back. The index is very detailed and very much part of the house style of Sweet and Maxwell, and it's what we've come to basically depend on as much as anything else. So a big thank you to everybody concerned who've been involved in the production of this book. As I've said, we do need it for our practice, and it is certainly a definitive work. Thank you to all. Bye-bye.